Welcome to this webinar this evening, and thank you for joining us on this February evening. As I said, this is brought to you by the Garden Court of Protection and Mental Health team. My name is Tim Baldwin. I've stepped in for Bojana this evening, and I'm one of the co-conveners of the team. That is, one of the co-leaders of the team. So what we're looking to cover tonight under the title, Returning, How Does Repatriation Work in a Court of Protection? It is the idea of returning someone home from abroad and how this works within the Court of Protection. With more and more people deciding to relocate to different parts of the world, in this webinar, we look at the jurisdictional and practical issues encountered in cases in the Court of Protection, and that is looking at considerations of a person's best interest when they lack capacity to make decisions themselves or have difficulty with those decisions, and in particular to return live permanently in a country abroad, that is return from, or to move to live to a country abroad, or to travel on a temporary basis to visit their family or friends abroad. And as I said, that this will look at, in particular, the law and procedure involved in dealing with people lacking capacity in this respect. We have two excellent speakers this evening on this very interesting subject. Our first speaker tonight is Acland Bryant. Acland appears in the Court of Protection, accepts instructions from families, local authorities, ALRs, integrated care boards, and the official solicitor. He acts in a full range of the Court of Protection jurisdiction, and Acland's background is as an experienced family law practitioner, and he specialised in cases of serious abuse, whether it be physical, verbal, sexual, emotional, psychological, or financial, and he's regularly instructed where there are serious allegations of abuse and complex medical evidence. Acland will be our first speaker. Our second speaker tonight will be Amina Ahmed, and Amina also practices primarily in the area of public law, care proceedings in the family court, representing parents, children, local authorities, and interveners. And she has an experience of cases involving complex non-accidental injury, sexual abuse, and cruelty and neglect, and has acted in the Court of Protection. She deals with issues around disputes over care planning for adults under a disability and issues of financial deputyship. So we'll start firstly with Acland. So if Acland starts his session, then we can, once he ends that, then we can turn to Amina. Thank you.
Thank you very much for the introduction, Tim. So just to outline where I'm proposing to go this evening, I'm going to be looking primarily at the legal basis for considering repatriation within the Court of Protection, some of the key case law, the checklists that have been developed to assist practitioners in this area, and some of the important considerations and factors which you might want to keep in mind if you are dealing with such a case. I won't be focusing so much on the best interest framework and the analysis around risk. That's something that Amina is going to touch on and cover a bit more within the context of her presentation. So I'm going to move on to my next slide. So I'm starting off with Section 63 of the Mental Capacity Act. Section 63 deals with international protection of adults, and in particular, we're looking at Schedule 3, which gives effect to the 2000 Hague Convention. Make a note in respect of the 2000 Hague Convention, because I will return to that when discussing one of the cases later on. But it also, under subsection B, deals with related provisions in private international law of England and Wales. So that's the key provision that deals with international protection of adults within the Court of Protection's jurisdiction. Next slide, please. So the first question is, who do these arrangements apply to? And the answer to that is under paragraph 4, Schedule 3. It's adults with incapacity. It's defined within the Act itself. So an adult means a person has an impairment or insufficiency of his personal faculties, cannot protect his interests, and has reached the age of 16. You will note at paragraph 1, it says that it's subject to subparagraph 2. For clarity, subparagraph 2 reads as follows. So I was just touching on subsection 2. So subsection 2 says, but an adult does not include a child whom the following applies. And it's basically at subsection A, the 1996 Hague Convention concerning children. Next slide, please. So what measures can be taken? So in essence, what can be taken by the court are protective measures, and they're outlined within paragraph 5 of Schedule 3. You'll see from the list that protective measures are quite wide-ranging. Protective measure means a measure directed to the protection of a person or property of an adult, and in particular, the court may deal with the following: a determination of incapacity, placing an adult under the protection of an appropriate authority, guardianship, curatorship, or any corresponding system, designation and functions of a person having charge of an adult's personal property, placing the adult in a place where protection can be provided, administering, conserving, or disposing of the adult's property, authorizing a specific intervention, and subsection 2, where a measure or like effect to a protective measure has been taken in relation to a person before he reaches 16. This schedule applies to the measure insofar as it has an effect in relation to him once he's reached 16. So quite a wide-ranging provision. I've included at the bottom of the slide a reference to a case. It's a 2025 case. In this case, Senior Judge Hilda reviews the relevant case law and the legislation regarding the meaning of an adult, alongside its interaction with the jurisdiction under Article 14 of the Hague Convention. She concludes, and this is from paragraph 56 of her judgment, as to the connecting factor for jurisdiction of the Court of Protection in respect of the property of persons under the age of 16 who are likely still to lack capacity to make relevant decisions when they reach the age of 18, it is unnecessary for me to seek to formulate any generality beyond KS's, and I should say KS was P in this particular case, KS's own circumstances. The Court of Protection undoubtedly had jurisdiction over KS's property in England and Wales when the deputy was appointed, and it retains that jurisdiction after KS's habitual residence has changed to India, at least until a contrary step is taken in the new state of habitual residence. As a result, Senior Judge Hilda concluded that the deputy's appointment remained in place for the purposes of that case. Next slide, please. So what is the scope of the Court of Protection's jurisdiction? Under paragraph 7.1 of Schedule 3, the Mental Capacity Act, it identifies persons in respect of whom the full original jurisdiction of the Court of Protection is exercisable, which includes the ability of the court to make declarations and order under sections 15 and 16. That comes from another Senior Hilda case from 2019. She's referring there until paragraph 7.1, as I stated above, and 7.1 specifically sets out the individual circumstances. A, an adult habitually resident in England and Wales. B, an adult's property in England and Wales. C, an adult present in England and Wales or who has property there if the matter is urgent, or an adult present in England and Wales if a protective measure, which is temporary and limited in its effect to England and Wales, is proposed in relation to him. We're going to move on to touch on habitual residence in a moment. Next slide. But before doing so, a very quick note for everyone here. Important to realise that for the purposes of proceedings in the Court of Protection, both Scotland and Northern Ireland count as foreign jurisdictions. We know that they have their own legal jurisdictions, but they are foreign jurisdictions under the MCA as well in the context. Next slide, please. So habitual residence, I'm sure many of you on the link tonight will be familiar with habitual residence and the vast array of case law. I've cited here a non-exhaustive list of cases. The bulk of the case law has been taken from judgments in this area, i.e. cases dealing with repatriation and return orders. A couple of quick points to start with. Habitual residence isn't defined within the MCA. The authority of SW is a Moylan J judgment, and it held that the meaning to be given to habitual residence in the context of the convention and the MCA should be the same as for other family law instruments. So again, noting the link between the family court and the Court of Protection. And some of the key principles that have been outlined in cases are as follows. One, habitual residence is a question of fact. Two, the place which reflects a degree of integration by the child in a social and family environment, and it's concerned with the child's physical presence, although that should not be temporary or intermittent. Consideration needs to be given to the conditions and reasons for the child's stay. The essentially factual and individual nature of inquiry should not be glossed with legal concepts, which would produce a different result from which the factual inquiry would produce. Both an objective and subjective factors should be considered. Equally, it's better to think about habitual residence in terms of reasons why a person is in a particular place and his or her perception of the situation while they're, in other words, their state of mind. It is the stability of the residence that's important. Habitual residence is to be assessed by reference to all the circumstances as they exist at the time of assessment. Next slide, please. Two other key authorities. One here is LC, and this is the key quote from Baroness Hale, as she then was. I won't read that out in full. You will receive the slides after this webinar, and the other is SW from Moylan J, which I referenced a minute ago. Just a couple or four additional points that I picked up. Different factors will have differing relevance to different degrees in different cases. The degree of integration is an overarching summary or question rather than the sole or even a primary factor. Integration is an issue of fact, and it can be a motive and loaded word, so you need to think about that very carefully, and the court should not lose sight of the wood for the trees. Next slide, please. Moving now on to some of our key cases. This first case is a relatively recent case, 2021, which came before Mr. Justice Hayden. The reason why this case is really helpful is that the judge towards the end of the judgment outlines his checklist, which is a non-exhaustive checklist that can be used by practitioners in repatriation cases. The judge also sets out the orders and the directions that he made, so it's quite useful to look at in terms of how he writes the various orders and direction he gives. But to provide a brief overview of the background, the case concerned UR, who was a 68-year-old Polish woman. She had delusional order and comorbid depression. UR moved to to the UK from Poland in 1972 at the age of 20, but she would go back and visit quite regularly. This was a Section 21A challenge. The key question was, where should Juar live? Whether she should remain in her care home in England, or should she return to live with and be cared for her family in Poland? In this case, Juar had been expressing consistently a wish to return to Poland, and the court noted that her wishes were unwavering. There was an unwavering consistency of those wishes, and that was striking and unambiguous. Ultimately, the court determined that Juar was habitually resident in the UK and made Section 15 declarations as to her capacity, and then decided that she should be repatriated to Poland. Some of the key factors that the court considered as part of the best interest analysis were the length of time that she had lived in Poland, the fact that she'd maintained a consistent connection with Poland throughout her life, the clarity of her expressed wishes and feelings, the fact that a return home was viable both from a physical medical perspective, but also from a mental health perspective. And there was sufficient evidence for the court to find that Juar would be sufficiently cared for in Poland and that her needs would be met. But we're going to focus more on the checklist that was provided by Hayden. If we can move to the next slide, please. Here's the checklist. As you can see, it's quite a long checklist. There's 13 different points to consider. Some are more practical in nature, some have more of a legal stance. It's a non-exhaustive list, so the judge was opining this list in the context of the facts that were before him and after hearing submission from counsel and lawyers involved in that particular case. But to start with, there needs to be, it's proposed that there's early liaison with the relevant embassy and consulate. There's evidence of physical health to travel, evidence of mental health to travel from a psychiatrist, legal opinions, if necessary, regarding citizenship, benefit entitlement, social care provisions, consideration of any applications that need to be made in light of any legal opinion, independent social work evidence regarding viability, confirmation of travel costings and who's going to pay for those costings, confirmation that the necessary medication and care will be available during the travel and for the immediate future in the new country, that there's a detailed transition plan and care plan and a contingency plan, best interest evidence from the relevant commissioners, wishes and feelings evidence, residual orders to allow the plan to be implemented, including single issue financial orders regarding opening and closing of UK bank accounts, the purchasing of essential items if necessary, and COVID-19 considerations. As you will have noted from the previous slide and also at the header of this slide, the case was in 2021 when we were at the height of pandemic time. So COVID was a real live issue, including the restrictions on travel. Before moving to the next slide, there's a couple of points to make. This is OCTA, so it's not binding law per se. It's non-exhaustive, it's non-prescriptive, and so in each case you need to consider the facts as they are presented and look carefully at the checklist. One example where you might not start with liaison with the relevant embassy is where you have a P who isn't expressing consistent and unwavering views about moving back to their country of origin, and their wishes and feelings might be fluctuating between wanting to stay where they are, to move or relocate within the UK, or to move back to their country of origin or some other jurisdiction where they perhaps resided previously. In those circumstances, you might want to think about whether P's wishes and feelings should be explored more thoroughly over a slightly prolonged period of time by both social worker and by P legal representatives, if P is represented by his or her litigation friendly official solicitor and P has his own legal representatives, to assess if there's any consistency, to assess the extent to which he is advocating for a move back to their country of origin, to understand what P's connection with that country of origin is, what they understand it to be, because some people might have moved to the UK at a very early age and might not remember what life was like before having moved to the UK. So you need to consider the checklist very carefully and apply it flexibly. Next slide, please. Just a couple more notes here from me. A couple that I've already touched upon. Number one is that this case is quite specific in how it deals with COVID-19. That's unlikely to be as relevant now in a post-lockdown world. Secondly, and this is where I said I'll return to the Hague Convention. At the time of the judgment, the UK hadn't ratified the 2000 Hague Convention. That's still the case. The need to consider ratification of the 2000 Hague Convention is a very important point, because in any case where both jurisdictions are signatory, central authorities need to be involved in the planning stage so as to comply with Article 33 of that convention and paragraph 26(1) of the Schedule 3 to the Mental Capacity Act 2005, which will come into force upon ratification of the convention. You can note that Scotland has itself ratified the convention, and so it would be a state where you need to consider the Hague Convention and how it would apply. But at present, as I say, the UK is not UK-wide ratified. It's not ratified here in England and Wales. Next note is that UR applies where an individual is at the time of the judgment habitually resident in England and Wales. And so the court is exercising its full jurisdiction. It might be different, and different considerations might apply if you're acting to give effect to a foreign order for return. And I've cited there the case of Re-MN, and that might be one to go and look at for comparison. Next slide, please. So moving on to a slightly different case and different context. This is the case of AB and XS, and it's a case where the court was essentially asked three questions. It was asked to consider where XS was habitually resident, whether it should exercise its inherent jurisdiction to ask for XS to return to the UK, and see what XS's best interests were. But I will focus more on the inherent jurisdiction point. And just to outline the background facts, there's a lot there. I'm not going to read it all out word for word. As I said before, you will get the slides after this webinar. But XS was or is a 76-year-old woman. She was residing in Lebanon and was a dual citizen with the UK. The applicant was her cousin, AB. She sought for XS to be returned to the UK. XS was born in 1944 in Lebanon, came to the UK in 1971 and acquired UK citizenship. In 2013, she was diagnosed with Alzheimer's disease and was detained for some period of time under the Mental Health Act. In 2014, she moved to live at a care home in North London. She was discussing wanting to go to Lebanon to visit her family and friends. And later in 2014, she did in fact go to Lebanon, and she moved into a flat very close to that of her brother, who sadly died in 2016. Following R's death, XS moved to live in a care home in Beirut, and XS hadn't, the applicant who, AB, had not seen XS since 2015. There were some Lebanese proceedings, and there is quite a lot of background regarding the extent to which those Lebanese proceedings had a bearing on the present application, the various orders that were made and concerns raised. There was an expert appointed to advise the court on Lebanese law. But essentially what happened was the applicant commenced proceedings in the UK in 2021 and sought rulings on a return to an order for return, access to return to the UK, and also an order in respect of LPA. In making the application, the applicant relied on issues facing Lebanon at the time, issues around economics, shortages of medical supplies, issues that arose from shortage of medical supplies, including health risks, the uncertainty of when they would stop. Equally, there was an explosion in Beirut in 2020 that actually damaged the care home that XS was staying in. XS moved out. She was not harmed by the explosion, was able to return with other residents. There were no issues raised in respect of the care that the care home was providing to XS in and of itself. It was more the surrounding circumstances of that particular jurisdiction. Next slide, please. So in terms of I should say again that in relation to the three questions that I outlined before, the court essentially said and found XS was not habitually resident in the UK, declined to make an order under the inherent jurisdiction, and also found that it wouldn't be in XS's best interest to return to England and Wales. But focusing on the inherent jurisdiction point, the court said that there was no doubt that it had the power to make the order that was being sought, but said that there are limits on how the inherent jurisdiction could be used. And the court cited and mainly relied on Cobb's judgment, Mr. Justice Cobb's judgment in Re QD 2029 case. I've underlined and put in bold the kind of key parts, or certainly what I consider to be the key part of that paragraph, which says there is a comprehensive and robust statutory scheme available in the Mental Capacity Act 2005, which covers in section 63, which we looked at earlier, this very issue. To apply the inherent jurisdiction here would be to subvert the predictable and clear framework of the statute in an unprincipled way. Next slide, please. So a couple of points to note from the judgment in this section is that a clear justification will be needed to rely on the inherent jurisdiction when the Mental Capacity Act 2005 bites. Given Leave and J's judgment, I should say this is a Leave and J case, on habitual residence, all of the previous directions in the case, for instance, the instruction of the expert, were made under the High Court's inherent jurisdiction. And those directions made by Leave and J to enable examination of the position and informing the court of the position were considered, must have been considered not to be cross-cutting against the nature of the MCA. So that's an example of where the inherent jurisdiction doesn't cut across the MCA. In relation to the substantive application, whilst deciding to make a return order, Leave and J stressed that a case concerning the inherent jurisdiction, the court must retain some flexibility and each case must be considered on its own fact. So she certainly envisages a situation where the Mental Capacity Act applied in this context, but it still would be right to invoke and rely on the inherent jurisdiction. At first blush, it's quite hard to think of a case where that may be so when Section 63 is engaged. One possible situation, and again, this is just my thoughts on this, may have been if Leven had been persuaded it was in Exile's best interest, in fact, to return home, or to the UK, I should say. At that point, there would seem to be at least some form of argument that the use of the inherent jurisdiction would be appropriate. Firstly, to plug the protection gap, but also secondly, to promote what is one of the core and guiding principles of the Mental Capacity Act, which is best interests. Next slide, please. And I'm wrapping up now. This is going to be my last slide before I hand back to Tim and Amina. This is a repatriation checklist that I've taken from the Court of Protection Practice or Handbook. It's slightly different to the one that we looked at in the context of UR. It's much more practical in nature and focuses much more on the arrangement. So you can see from point 1 that you need to consider the proposed date for repatriation, think about key contacts, the role of the receiving care home and nursing home, who's accompanying P, which care home staff will be involved, how the costs are going to be met, arrangements for medication, transfer of personal belongings, transfer of money, travel arrangements, whether all the court orders have been obtained and passport and travel documents. So there is certainly some overlap with some of the matters that Hayden J outlined in UR, but there's perhaps a little bit of extra practical detail on points within the Court Protection Handbook that ought to be considered when particularly looking at care planning, transition planning, and so on. Again, this isn't exhaustive, it's indicative of some of the key areas of consideration. And again, each case must be considered on its own facts. That's going to be the end of my presentation. I just want to say thank you very much for listening to what I've had to say about repatriation. And I look forward to your questions towards the end. Thank you.
Thank you, Acland. There are a couple of questions that already come up, which we'll address at the end. We'll now move on to Amina, who's going to start her presentation now. Thank you, Amina.
Thank you, Tim. Well, welcome everybody. I'm going to be speaking on the issue of travel abroad, but temporary, either for holidays, family visits, attending funerals, and the like. And this is in the context of the person going for a limited period of time and then returning to the UK. So on the first slide, thank you. We are going to look at how the Court of Protection approaches decisions about foreign travel and look in a bit more detail at the Court of Appeal decision in Re J, which really draws together the issues that need to be considered when planning travel abroad for someone who lacks capacity. So on the next slide, Re J, in brief, it's a very short judgment, so it won't take too long if you want to go and read it. This was a young adult with severe learning disabilities. Family proposed to travel to Afghanistan for a 5-week holiday. The family had successful asylum claim in the UK. Jay had also been the subject of forced marriage protection orders in the past, although by the time we come to this holiday, that wasn't really a live risk. And importantly, the Foreign, Commonwealth and Development Office had at that time advised against all travel because of risk of terrorism detention, and there was no consular support. So moving on. Next slide. The first instance decision was made by Mrs. Justice Roberts. Essentially, she found that the risks identified by the Foreign Commonwealth Office were grave and that there was no mitigation for them. She did consider the cultural and family benefits, but considered that the risks outweighed the benefits. And she did note that P's wishes were very positive, but again, the risks outweighed those. So moving to the next slide. This was an appeal, in fact, by the official solicitor. The Court of Appeal dismissed the appeal, identifying the points you see there, that the judge had conducted a proper best interests analysis. The guidance was not determinative in her judgment, but was treated as evidence that there were real risks to consider. P's values and wishes were acknowledged, though not detailed in the judgment, and this was an important point in the appeal, in that Mrs. Justice Roberts' initial judgment had not dealt separately with P's wishes and feelings, although she had evidence about them from both on behalf of P and also through the local authorities' evidence. The Court of Appeal considered that the decision was not in any way discriminatory, either in respect of the cultural factors or by dismissing P's wishes and feelings. And I'll come on to that. There was some submission that the court had taken a more paternalistic view, that P could, if he had had capacity, have decided to ignore the Foreign Commonwealth Office guidance, as any person with capacity is entitled to do. And then the additional risk factors which applied really in this case personally to P. He had an expired Afghan passport, and the asylum history could, of course, have heightened concerns because plainly the family had left Afghanistan for good reason. Next slide. So looking at the legal framework, I'm sure that everyone is very familiar with the key sections of the Mental Capacity Act, but I've identified there the ones that I think apply to all foreign travel decisions, whether you are looking at repatriation, as Acland discussed earlier, or full shorter visits. Very familiar presumption of capacity, the issue of unwise decisions as opposed to incapacitous decisions, the functional test and best interests analysis. Section 5, I think, just to highlight, of course, any application seeking to either restrict or deny travel abroad does, of course, restrict P's liberty of movement, and the court will be very alive to that. And of course, we also need to be aware of the issues surrounding the limitations on restraint and decision making, and the proportionality of the decisions in response to P's, the likelihood of P suffering harm, and in particular, of course, in Re J with the proposed trip to Afghanistan, the seriousness of any harm should it occur. Next slide, please. So, looking then at when does an application need to be made in the Court of Protection, you'll see at the bottom of the slide, I put routine low-risk holidays with no disputes may fall within Section 5, and those decisions can be made. So, for example, where P has a family who has a holiday home abroad and there have been previous regular visits to that with no issues arising, P can tolerate or even enjoy traveling, and there's no professional or family disagreement about the trip, then no application needs to be made. you will need an authorization where there's a significant risk associated with the destination itself, where there are whether it's a war or civil unrest of a serious nature going on, and consideration will be given particularly to if it's a large country and there is civil unrest or high risk of terrorism in one part, that may, of course, not affect the whole country, and it may be safe to travel to another part. So some consideration needs to be given to that, where the travel might affect where P resides or their long-term care. And if there are safeguarding concerns, and in particular, the issue of forced marriage, trafficking, or the risk of non-return. And those are all individual concerns, really, that have to be analysed in P's own situation. The forced marriage issue had come up in Re J. If that is an issue, the court will need to be very clear that the family who are going with P have abided by previous orders, that any risks that may have been apparent or alleged at the time of the application for forced marriage protection order are no longer a risk. But that certainly will be a reason to make such an application. Next slide, please. So, of course, the court will need to be satisfied that P does lack capacity to make a decision about foreign travel. The considerations are reasonably complex. He must be able to understand the trip, that they're going on a trip rather than a permanent move, the duration and purpose of that. Are they going for a holiday? Are they going for a funeral? That sort of thing. P must be able to weigh up the risks and benefits, and that includes any safety concerns. So effectively, that if it is a safe country to travel to and there are no concerns, then that is one thing. If there are issues such as there are with a trip to Afghanistan, that is going to be a more complex consideration for P. P must also be able to weigh up the issues surrounding any health conditions that they have and the consequences of not being able to return. P must also be able to understand the arrangements for accommodation, supervision, medication, and emergencies. And going back to Re J, at first instance, the judge found that J lacked capacity because he couldn't weigh and balance the information relevant to risks associated with Afghanistan. So while he might have been able to understand that there were risks to him going, he could not weigh them appropriately with the benefits and with his own wishes. Next slide. And so in relation to best interests, the courts must consider all the relevant circumstances, as in any best interest decision, P's past and present wishes. Cultural identity, heritage, and family connections may be relevant for some travel. If it's just a family holiday where P and his or her family have no particular connections, that's less of a consideration. But of course, the issue of being able to be a part of a family holiday is something that should be included as a benefit to P. Physical safety and security, and importantly, the impact of separation from family if P does not travel. An obvious disbenefit to P is if P knows that he is missing out on an experience that the rest of the family are going to be enjoying. And then something that was particularly considered in Re-J, if there are risks, can they be mitigated? And is that practical? Next slide. And looking at those risks, those of course have to be evaluated. What is the type of risk? Is it terrorist activity, detention, and so on? The likelihood of that risk materializing and the severity of the consequences if the risk does occur. So even if there is a very low probability of that risk occurring, if it does occur, the consequences may be so serious that no mitigation is going to be able to make this a safe trip. And in the case of J, it was the risk of detention with no prospect of support. So if the risk that you have identified is a low one, you still must consider what impact there would be on P if that did occur. Next slide. In relation to wishes and feelings, in Re-J, it was argued that P's wishes and feelings should not be minimised simply because he can't understand them. But the Court of Appeal took the view that while his wishes formed part of the best interests balancing exercise, they weren't a substitute for it. J, in that case, was very keen to go to Afghanistan and had talked quite excitedly about it. But of course, however keen he was, that didn't outweigh the obvious risks that he faced. Next slide, please. So going back to excessive paternalism, which I briefly touched on earlier, the Court of Appeal did approve this passage from Headley J. The intention of the Act is not to dress an incapacitous person in forensic cotton wool, but to allow them as far as possible to make the same mistakes all other humans are at liberty to make and not infrequently do. So, Court of Appeal clearly recognising that any trip abroad is not risk-free and shouldn't be, that P should have normal experiences, but that doesn't extend to exposing P to risk of life, limb, and liberty, and that the judge considering any application must differentiate between ordinary life risks and acute dangers. So, for example, if the family are going to a hotel where there is a swimming pool, it may be that there is a risk of P falling in. That might be an ordinary life risk or a natural disaster that no one predicted. That's a risk. And then there are situations that Jay would have faced had he gone to Afghanistan, which are rather more predictable and not in the scope of ordinary life risks. Next slide, please. So the Court of Appeal also considered the role of the guidance and travel advice. It's not binding, but in this situation, it did reflect undisputed facts. So the court was entitled to give that significant weight. But again, it's not determinative, it's part of the balancing exercise. Next slide. So drawing together what we have seen in Re J, I put together some practical considerations if you are either faced with an application or seek to make an application for P to travel abroad. There should be, along with the application, a capacity assessment in respect of travel to the proposed destination, and perhaps what I should have added there, for the proposed purpose. So not a general capacity assessment, travel in general, but for the specific trip that is being contemplated. There should be a risk assessment addressing concerns specific to the destination, evidence of safety measures if required, accommodation that P will be staying in, whether that is location, accessibility considerations, supervision of P if that is relevant, and also, if relevant, evidence of a family's compliance with forced marriage protection order. So if the order was made 10 years ago and the family have complied fully and there's clear evidence that they understand why the order was made and what it prevents, then that can be positive evidence, but it does need to be addressed up front. You will need any medical evidence in respect to P's support needs, whether that is care that can be offered, any changes to care that might be required on holiday, or, for example, if P gets anxious on aeroplanes, is medication needed? There is also possibly any work that might be done with P to prepare for travel, such as familiarization with airports or trains or those sort of things. Has there been any change in P's condition, physical condition or behavior since, even if there's been a prior successful trip? If there are any changes, those need to be addressed. Again, if relevant, you will want to put in cultural evidence, heritage, family ties, what the community context is. Are they going to visit family, or are they going to visit an area or a place that is particularly meaningful to the family in a cultural way? Ensure, of course, that travel documentation is complete, so that really there should be a passport and any asylum-related risks are dealt with in the application. If you are looking to point out that they're no longer relevant, that should be addressed at the beginning. And then, of course, the standard funding and insurance to include any high-risk reasons, but additionally, if P has particular medical needs, any pre-existing conditions, to ensure that that appropriate insurance has been at least identified and priced up. Next slide, please. There may need to be some liaison with authorities that will be relevant for some destinations. If P has an ongoing medical condition and may need urgent medical assistance, and that's relatively predictable, it's a good idea to have at least identified local medical providers, whether that's hospital or primary care in the area where P will be staying. And of course, safeguarding issues where forced marriage or trafficking concerns either exist or have existed in the past. Next slide, please. Contingency planning, again, that's something that will need to be clear in the application. So emergency medical plans, backup travel arrangements, contingencies for anything that's reasonably predictable that might happen, and then any geopolitical risk and any strategies that might be undertaken. Although in the case of ReJ, as you'll see, some risks are so serious that really they can't be mitigated. Next slide, please. So when should the when should an application be made? So is there uncertainty about P's capacity? Is there disagreement about travel, whether that's disagreement between P's family members as to whether or not P should travel, or disagreement with professionals? The travel is to a high-risk location, and of course, if P is subject to forced marriage protection order, an application will be needed. But if it may be that in any event, the forced marriage protection order, there will need to be an application made to vary that as well. But if there has been a past forced marriage protection order issue, an application will be needed. Next slide, please. So that is just a summary of what needs to go with your application. I think we've covered all those. Of course, if there is relevant guidance about advisability of travel, then of course do put in a response to that, so that the court is aware that that has been considered, and that you have a response to that and a proposal about how to mitigate any risks. And I would say that this does apply to urgent applications as well as pre-planned ones. So if the family are planning to go in 6 months' time or a year's time somewhere, then it is a much easier job to get all this material together. But of course, there are situations in which, for example, if it's family funeral, you have much less time to prepare, but the court will need to have as much of this information with the application as is possible, even when the application is relatively urgent. So that hopefully gives you an idea of things to be aware of where you're either proposing to make or are respondent to any application. So thank you very much.
Thank you, Amina. We have a number of questions. I think it's useful if Acland comes back as well, that some are aimed at Acland. If I just read the first question, there are 5 questions in the list so far, and if anyone else has any further questions, please put them in the chat. The first question relates to an issue around deputyship, and I might just, the question seems to be, can deputyship remain in a court of protection even after they move? Question mark. It says, I have a case where P has been told there is no equivalent to manage finances and property here. I'm assuming that's where they move to, therefore they have to remain here. So it appears as if the question is if somebody is to move, can they move if there is no legal equivalent to manage finance and property, and in the absence of something in another jurisdiction, are they compelled to remain in the UK, or can the Court of Protection deputyship be recognised in a jurisdiction where there isn't an equivalent? I think that's what the question's aimed at. I mean, I've elaborated on it a bit, but it seems as if the person has been told they can't move because there's no equivalent provision in the country to move to, and the question is, can the deputyship remain in the UK even if they do move? I think that's Acland might want to have a pop at that first off.
Sorry.
I'm happy to have the initial go at that one. So, I mean, the 2 issues that looks like being considered. One is the kind of financial and property issues. The second is residence, i.e. where this person is living. I would say it's not uncommon for a person to be living in one jurisdiction and still retain property or finances in another jurisdiction. If it's the case that P is already living in the other jurisdiction but has property remaining in England and Wales, you can still keep a deputy here within England and Wales, and the Court of Protection can still keep some jurisdiction. If you think back to my slides in paragraph 7.1, the scope of the jurisdiction, 7.1b is an adult's property and it is in England and Wales. So the court does retain that jurisdiction in those circumstances. If it's slightly different scenario and the court saying, well, I don't want P to be repatriated to another country because there's an inability for them to have a deputy in that country that they're looking to move to, I would say that isn't necessarily a bar to them moving if the welfare facts are right, or as they present. And of course, we don't know the particular details of that. It might be preferable to think about a deputy or someone who can act as a deputy where P is, because it makes it easier to keep a relationship with P. But I don't think it's a bar in and of itself. But as we know, with a lot of court protection things, the cases are so fact specific, it's difficult to go much further than that. But in the sinful sense, I don't think it's a bar. And yes, the Court of Protection in England and Wales can keep jurisdiction in relation to property and finances should P be in another jurisdiction.
But is that only in respect of property and finances in England and Wales. For example, if a property was sold in England and money was to proceeds of the sale were to be transferred to the other jurisdiction, what would, say, the Court of Protection be able to authorise the deputy to manage that in a foreign jurisdiction, or would it require a foreign court somehow to recognise that order?
I think in that circumstance, it will likely require a foreign court, because if you think back to, again, Section 7, courts only got jurisdiction if habitually resident, the properties in England or Wales, adults present in England or Wales, or who has property there, adult present in England, Wales, and if a protective measure which is temporary and limited to the effect of England and Wales. So that set of circumstances would seem to fall outside of that scope. Unless you, Tim, or Amina take a different view to me on that.
And if the other country is a Hague Convention country that's fully ratified, or because there's a difference between in the UK, there's sort of recognition of the Hague Convention, but not ratification. There's a whole table out there. If there's either a ratification or a recognition, would that lead to anything in the other country, or would that still require the other country to either recognise or would that require the other country to effectively adopt the jurisdiction, as it were?
It would, if the other country was a Hague Convention, on first blush, I'd say it'd make life easier, because there is a greater extent to which jurisdictions recognise what's happening within the other jurisdiction. As for the particulars, I couldn't go further than that, I don't think, at present.
Amina, do you have anything to add?
I was going to add that the question might be assisted by the case, what was it, Irwin Mitchell Trust Corporation and KS. It was a judgment by Her Honour Judge Hilda. In that case, it was a girl who had damages, so quite substantial amount of damages, and the deputy had given permission for property to be bought in India, and they were going to relocate there, although it is fair to say that the remainder of the assets did remain in England and Wales. And the deputy's application was refused. They wanted to withdraw, but Judge Hilda decided that in this circumstance, their authority could continue to extend over the property and affairs in England. So they weren't discharged. So I think, in summary, as long as there is some asset in this country, the deputy can oversee that there is a way for someone to relocate permanently while still retaining a deputy here.
But that deputy only has power over the asset here, is that right?
Yes, yeah, that's right. So while there had been a decision to purchase property in India, the remainder of the money remained here, and so any further spending would of course be controlled by the deputy in this country.
I mean, if my experience of this has been is if the court if he has expressed a view um, as to wanting to move to uh, a country, the court protection does try and require the local authority or official solicitor to investigate that issue, but then they have to be satisfied effectively that there are care and support arrangements in that other country to meet that person's needs, and often issues around managing finances can be problematic in a foreign jurisdiction. I've even seen it in Scotland, believe it or not, even there there is that issue. Um, a number of other questions have come in. I'm going to take one question out of turn because I think it's related. It's somehow related to this, and the question is this: to what extent will a return order be made by the Court of Protection be enforceable in a jurisdiction to which P has been taken? For example, an order to return P from the United States.
Amina, do you want to go first or
No,
something?
you start.
I was going to say in terms of just imagine that an application has been made in the Court of Protection here in England and Wales. You've perhaps had a return order made in the inherent jurisdiction, let's say. In terms of English and
Well, this is
Welsh,
a Court of Protection specifically. This
oh,
is
the Court of Protection, sure. So, yeah, I mean, as a matter of law here, that order is enforceable in England and Wales then, but it's not automatically enforceable in the US. It doesn't have extraterritorial effect in the same way. So you need to consider um, how to effect that order within the other jurisdiction. The US is a slightly complicated jurisdiction in that there's different state law, there's federal law, etc. I don't know the specifics of the US. I don't know whether you, Tim or Amina, do.
I mean, don't recollect it being a Hague Convention case
It's not
off the
from my
top of
memory.
my head, but I think because different states have different laws, and particularly these notions of what they call conservatorship, I don't know if there's any federal jurisdiction for this issue, but it's going to depend, I think, whether um, that either the state or the federal jurisdiction recognize the order made by the UK, the England and Wales court. I mean, there are various different types of conventions about recognizing court orders, um, but I would anticipate that it would depend primarily upon whether either probably a state court would recognize the court protection order and seek to, adopt it effectively to return the person. I mean, I would anticipate that this is more common within the family jurisdiction than the court of protection. I've not encountered this myself, but that's what I would anticipate that it would be. Um, the problem is you can invoke all these various conventions that you want. The US is not a signatory, or um, I don't even know if it's a signatory to the Hague Convention on disabled adults, but I'm pretty sure it's not ratified it, and it would likely be a state court that deals with the issue because of these different laws on what's called conservatorship in the US. They seem to be state related. Amina, can you help us on any jurisdictional issue with, say, the family courts, by example?
Yes, I mean, I think it is similar. Obviously, if you have a country that's signatory to the Hague Convention, then it's very much easier because there is a way forward in respect of adults under a disability. Um, in the cases I have come across, effectively any enforcement is really only here. So I think it was AB where the parents took P to Jamaica uh, and was uh, were effectively trying to evade proceedings and local authority involvement there. Um, the court did get, and the local authority did get a lot of cooperation from the Jamaican police, but essentially the only enforcement is really as against the parents uh, in this country. They still had a property here, and if if the proceedings hadn't started, they would still be living here. So they had sufficient links here to make enforcement on them a realistic proposition. Um, so it is in terms of sort of enforcement, it is really putting pressure on in that case on the parents uh, to return P uh, by the leverage that's available in this country.
But was there any application to a Jamaican court to recognise that, to enforce, assist with enforcing the return?
There, in fact, I think the first application, I mean, the Jamaican court was involved, uh, but I think as a result, initially, let me see. Oh, yes. In fact, the local authority hadn't at the time of this hearing, but they were proposing to instruct Jamaican lawyers to begin proceedings in Jamaica to invoke the Jamaican Supreme Court's inherent jurisdiction to make a return order. But of course, that's a Commonwealth country, and so that process is easier. So certainly, there is no reason an application can't be made by, well, in this case, a local authority for if the country in question has a mechanism for enforcing a return.
Yes. Yeah, I think this can sometimes even be problematic with Scotland and Northern Ireland. That you do have to go through their own individual jurisdictions.
Yeah.
The next, there's a short question for Acland, and it says, "Did UR lack capacity?" The question doesn't say in what domain, but was UR in that case lacking capacity?
Yeah, in the relevant domain, yes, they were. There was a number of capacity assessments over some time, which was found to have capacity in various areas at different points of time. But for the purposes of residents and being repatriated, she was found to lack capacity, and final declarations were made.
There is a link. I'm not sure if it's a linked question on that. I'll, I'll address this first off. It says, the question says, "I didn't realise the Care Act applies beyond our borders. Do we write a care plan on our care plan documents?" The Care Act per se does not apply to our abroad. It's kind of a complicated issue because if one looks at section 128 of the Care Act, what it says under 1, the Act extends to England and Wales only, subject to subsections 2 and 3. And it's reference to amendments, and it also says, and there are particular provisions within that Act that does apply to Scotland and Northern Ireland about cross-border placements and temporary duties, cross-border areas, and various transfer orders, and so on and so forth. But within England and Wales, in the adult jurisdiction, in particular, it's the Social Services and Wellbeing Act, Wales 2014, which is the equivalent. So, although it's confusing in terms of how the Act actually applies, it's limited to mainly limited to England in terms of its operation. But I think in terms of what is being asked here is that um, looking at both Acland and Amina's talk, that what actually is there is that Care Act assessments that are often specifically made in respect of care and support of that individual are used to support these orders because they identify the care needs of that individual and what they would need. For example, if they're going on holiday abroad, or if they were traveling on an aircraft, what they would need in terms of carers and whether carers should go with them. Is that roughly how the Care Act assessments apply in the context of um, these moves abroad or whatever? They inform the Court of Protection of the care needs of the individual, what the court would need to be satisfied to be in place in the other jurisdictions. Is that right?
Yes, I think that's right. The court really must have a standard to measure the destination by, if I can put it that way. So P's needs need to be met, and the way that's evidenced is by the Care Act assessment.
Okay. We've got about 5 minutes left. I'll try and deal with the remaining questions. There's a lengthy question. It says, if the Commissioner P's care, and other relevant persons are agreed and satisfied in terms of plans regarding P's adult who resides in a care home and lacks capacity, level of need, so is not able to communicate any wishes and feelings as being in their best interest, would this require an application to the Court of Protection? It says P had lived in the UK prior to the accident, but family are based in Italy, and it's Italy where the mother wants P to return to. If COP proceedings are required, would this be 21A challenge? I don't think it would be a 21A challenge per se, because it's a personal welfare decision outside of a challenge to a deprivation of liberty, or challenge. A 21A challenge is primarily to the deprivation of liberty under standard authorization. So I'd understand this to be an application under the personal welfare pathway under Section 16 if the person lacks capacity. Is that your approach to that question? It's quite a lengthy question, but I think it's the nature of the proceedings which are sought. It would either be a Section 16 or a combined Section 16 inherent jurisdiction application. Is that what you understand it to be?
Yeah, I would agree there.
So that's it. I think there's one more question. It says, if P has a health welfare attorney deputy and there is a disputed, it says, best interest decision about going on holiday, is the attorney's deputy's responsibility to bring the COP application if it's a dispute between, would they have the responsibility to bring it to court?
Yeah, well, I suppose it would depend on who who the dispute was with, and P's care arrangements. I mean, if P is in for example, supported living, and the local authority is providing that, or is the supervisory body, then it may be that the local authority chooses to bring that application. I mean, it's essentially, I'm take the view that it's the person that wants P to go on holiday that is likely to be the one bringing the application, because if the deputy, for example, is opposed to the holiday, then they can just sit back and say, well, no, I don't agree. And whoever it is that wants to take P abroad will have to make the application. If it's an issue as between the deputy, who thinks that P should be able to go on a family holiday to wherever, say low risk holiday to Spain, for example, and the local authority is opposing that, then there is absolutely no reason at all that the deputy wouldn't be the one making that application, because again, the local authority is not going to be particularly invested in paying money to go to court to back up a decision that they've already made.
It might also depend on whether the deputy is a welfare deputy or a finance deputy. So I've known some finance deputies being very parsimonious with people's finances and saying, well, we're not going to spend money on their holiday kind of thing. But that's a classical case where there's a conflict potentially of the deputy exercising the best interest jurisdiction properly. I mean, I think that addresses all the questions that I've seen, and hopefully we've managed to address the questions that have been put. There is one question about fitness to fly, but I think we've run out of time on that one, unfortunately, and it's very case specific. So I think we're going to have to call it a day at the moment. I think we have to thank everybody for attending. Our next event will be an event with the legal action group on the implications for various implications for the new Mental Health Act, and that's going to be on the 27th of March. So that's just a bit of advertisement for that. So thank you all for attending. Sorry if we haven't addressed all of your questions, but hopefully we've managed to address the key ones. And if there is something that you'd like a follow-up on, please let us know. As a result, I think we're going to have to end this session. Thank you very much for attending. It's 7:03, so we've overrun by 3 minutes, but we were 3 minutes late in starting. So thank you all very much for coming.